Once the Supreme Court ruled against me, which took another year or more, then the military tried to prosecute me for those cases at Pearl Harbor.
Right.
And the ACLU intervened and got that thrown out by, I think I was found guilty on those.
In the district court? Or
But the ACLU appealed it or asked the court, and it was declared illegal. It was ex post facto is the term I recall.
yes.
Meaning after the fact.
Right.
You can't wait till you change the law that favors you and then prosecute for somebody for something that happened before that law was changed.
This is my good friend, Jim Albertini, who wrote one of my letters of recommendation to law school. Jim is the only person I know of who has appeared as defendant or litigant before the U.S. Supreme Court twice for two unrelated cases. One of Jim's cases is discussed in Glennon's Guide to Crim Law under the topic of one of the few times a defendant can use mistake of law as a defense.
Hickam Air Force Base announced in the newspapers it was having an open house for Armed Forces Day in May, usually around May 20th. I don't remember the exact date that year. But the public was invited to the Armed Forces Day open house. They were going to have numerous aircraft on display, B-52s, other bombers, and they were going to have 3 different stages of music: Hawaiian music, country music, rock music. 50,000 people of the public attended that open house. So myself and about 8 or 9 others decided we would attend too and hand out leaflets underneath some of the bombers on display to people touring these planes. And within a few minutes we were taken into custody and kept for the whole day while the open house was going on, and then we were released without any kind of charges. And about 2 months later, a friend drove into our farm here saying on the radio, there's a warrant out for your arrest. You're going to be arrested for trespassing for handing out the leaflets at the Armed Forces Day event. And anyway, what it was is I'm being charged for trespassing for violating the ban and bar letter that was issued to me in 1972 as a result of the blood pouring action. Now, normally ban and bar letters are in effect for a year, but I guess in my case they decided it was going to be for life.
Okay. You say normally, like you.
Ban and bar letters are issued for anti-war activities.
But do they normally specify a limitation on the time?
In cases that I'm aware of, yes. My case didn't have a date on it, as far as I know.
But when you entered, you had the understanding that the first bar letter was not an indefinite time.
To me, the bar letter was irrelevant because this was an open house event where the public was invited.
Okay, so there are a few issues to unravel here. In 1972, Jim was arrested for an act of civil disobedience after entering a military base and pouring blood over certain official documents. Following that arrest, a so-called ban and bar letter was issued to Jim, enjoining him from setting foot on military bases. In 1981, Jim was again arrested on a military base, but for 2 reasons he believed that the ban and bar letter did not apply. One was the fact that 9 years later he presumed that the ban and bar letter was no longer operative. Another was because on this latter occasion the base invited the public in for an open house during which artillery, ships, and aircraft were displayed and entertainment in the form of music and shows were provided.
I was found guilty in this trial by judge of trespassing, violating the ban and bar letter, and sentenced to 90 days again in jail for that. And the ACLU took the case and appealed it. And we won at the Ninth Circuit Court level. And the issue with the Ninth Circuit Court was exactly what I was saying, that the public was invited that day, 50,000 attended. The only reason they even found out I had a ban and bar letter was because they took us into custody for exercising free speech rights. And the other 8 did not have ban and bar letters, yet they were taken into custody and kept, their free speech rights were denied at that open house. So that was the issue there, that the court said the base turned that portion of the base into a public fairgrounds for the day where free speech rights would apply. That we didn't go beyond the public area into some kind of cordoned off area. We stayed there and exercised free speech by handing out leaflets to people touring these warplanes. And so they said, the ban and bar letter aside, the issue is free speech at a public forum, turning that portion of the base into a public fairgrounds. So that was interesting. The military eventually appealed that, and I think it was 1985, I'm not sure the date, when the Supreme Court reversed the Ninth Circuit Court decision. And it was a split decision, 6-3. And basically what the Supreme Court ruled was that ban and bar letters were originated in 1909 to give the power to the military to keep people off the base that they didn't like. And it was originally directed at pimps, or people who were giving free rides to GIs to red light districts. And they wanted to keep them off. Technically, all they're doing is providing free taxi service, but they wanted to create a venue to keep them off the base. So that's how they were issued the ban and bar letters. Now, there's an interesting twist. So that's the long and short of it, that basically the decision affirmed the military's carte blanche power to silence dissent, even at events where the public is invited and 50,000 attend. They can use these ban and bar letters as a way to silence dissent. And I'll follow up on that. This is exactly what happened between the appellate court decision and the Supreme Court decision. Once the appeals court ruled in my favor, I asked the ACLU to write a letter to the Navy. Remember, this was Air Force at Hickam Air Force Base. I said, write a letter to the Navy, letting the Navy know I intend to come to the monthly open house events at Pearl Harbor, where they have warships on display, and exercise the very right the Ninth Circuit Court said I had at public events. So the Navy's response to that ACLU letter was to send Navy people from Oahu to the Big Island here, come onto our farm, and issue me a ban and bar letter from, I believe, about 50 different naval installations, many of which I'd never even been to. But it was in response to saying that I was going to come with a federal court, appeal court decision to exercise the free speech rights the court said I had. So here the Navy was issuing a ban and bar letter from all these different places to try and keep me off the base. And I can't remember all the details, so that would have been, I think, the action originally at Hickam was 81. I think the appeals court was 83 or 84, I'm not sure. And then the Supreme Court was, I think, 85. But in that time period, 83 or 84, that's when we were going. Yeah. Now, it's important to remember the context of this period in time. Reagan was elected in 80. This was the height of the Cold War, calling Russia the evil empire. Massive arms race and everything. So that's the context in which this is taking place. So, but anyway, when I tried to go to Pearl Harbor, to that open house event on the warship, carrying the federal appeals court decision, the Navy had a line of troops. When I tried to enter the base, they formed a line of troops, said, Mr. Albertini, you have a ban and bar letter. You can't enter. And I said, but I have a court decision, federal appeals court, saying that with the ban and bar letter from Hickam, I had a right to be at that open house. And they said, that applies to the Air Force. I said, well, come on. It's a Navy, it's a military base, open house event, you have a right to be there. The court decision did not just specify the Air Force, it applied to military bases, open house events. I should be able to go in. But they said, you're banned. I said, well, I'm not going to force my way through this entrance. If you're drawing a line here with your troops saying I can't proceed beyond here, well, I'll just stand here and hand out my leaflets. And within a few minutes, they came back and said, no, you have to leave. You're on military property. And I said, well, you drew the line with your troops saying I can't proceed beyond here. Well, the commander said, there's a new line. It's an imaginary line, and you're beyond it. If you don't leave, you're going to be arrested. So they arrested me, kept me for the whole open house, even though I was outside their line. And then they took me a mile or two away from where the main gate was and released me after the event. I was arrested 3 months in a row there at that open house. Once the Supreme Court ruled against me, which took another year or more, then the military tried to prosecute me for those cases at Pearl Harbor.
Right.
And the ACLU intervened and got that thrown out by, I think I was found guilty on those.
In the district court, or
but the ACLU appealed it or asked the court, and it was declared illegal. It was ex post facto, is the term I recall.
yes,
Meaning after the fact.
right.
You can't wait till you change the law that favors you and then prosecute for somebody for something that happened before that law was changed. So it was thrown out.
Well, see, this is the point of law that was being discussed in the book I just showed you, and that's why you're mentioned in it, because you are a textbook example of when an authority gives you permission to do something, and then that authority is later found to be erroneous. You still have an affirmative defense because you were acting on that authority, and you were acting on the authority of the appeals court.
Right, right. Now, but the whole basis here, this is what's interesting that, see, the Supreme Court didn't deal with, and they should have. They realized it's not just Albertini who was taken into custody on that Armed Forces Day. There were at least nine people, and none of them had ban and bar letter. They used this ban and bar letter as the excuse to get around national security. So that's the thing. The other people's rights were denied, and they didn't have a ban and bar letter. That when the military has open house events, the principle should be you can't segregate out the kind of public you don't like.
Justice Stevens wrote a dissent to the 1985 decision and was joined by Justices Brennan and Marshall, writing that, in his opinion, Congress did not intend to punish visits to a military reservation where the public was invited on, as here at this military open house.